Court, all rise, please. Hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court for our February 8th sitting. We are your panel for this morning. We're going to be hearing just two cases this morning. I'm John Englander. My great pleasure today to sit with my colleagues on my right, Justice Grant, and on my left, Justice Brennan. I think you folks probably know the rules, but 15 minutes aside, there is no rebuttal. We have read your briefs carefully, I can assure you. There's no need to go through background facts. If the facts are critical, you can tell us about them. Otherwise, I would get right to the point. So the first case today is the People's Freedom Endeavor and others versus the Andover Public School District and others, 22P 340. And the appellants, are we going to hear first from Attorney McLean? Yes, sir. And you folks are splitting your time 7.5 minutes each, is that right? Okay, you may proceed.
Members of the panel, may it please the court. Again, I'm Ryan McLean. I represent the People's Freedom Endeavor. Obviously, this is a consolidated case. The issue that People's Freedom Endeavor posed, even at the trial court level, was whether the Board of Elementary and Secondary Education has authority under General Law, Chapter 69, Section 1B, to implement statewide public health policies, essentially, including the face mask policy at issue. And the position was no, and that they're actually usurping the authority of the local boards, local bodies, including the boards of health, that have been given that authority by the legislature. We believe the trial judge erred in...
So can I just stop you there? Your position is then not the same as the position of your colleague who's sitting at the table with you?
It is not, Your Honor.
Okay.
And again, I think even in the transcript, looking at the record, it was used at the trial court level. I'm not in opposition. We ceded the position that the local boards of health have this authority. I think there may be a difference between trial strategy, and I'm not opposing, I'm not standing with the defendants opposing his position that they don't have constitutional authority. We ceded that for portions of our argument. But no, our argument is the same in so much as we argue that they don't have authority under the Section 1B of the statute.
State doesn't have authority.
State doesn't have the authority. So the People's Freedom Endeavor did not sue any local school boards or schools. We sued only Jeffrey Riley in his capacity as the commissioner and the Board of Elementary and Secondary Education. So ours, the People's Freedom Endeavors, is a single issue as to whether essentially the Board of Bessie, has the authority under Section 1B. And again, our positions they do not, and the trial court erred in finding that. The trial court judge found further in his memorandum that the statute gives authority to the board for any health risks, and that he made a comment that this was, we didn't show that they didn't have authority even in an unprecedented pandemic. So part of our argument is that he increased the burden, it not only increased the...
Well, why wouldn't they have authority? I mean, you've got two different provisions in the statute itself, right, in 1B, that you have to deal with. One, you say, and I think this is the 16th paragraph, and I'm struggling to find the language because, frankly, although the language should be front and center in everybody's brief, it's not. Okay, it gets there eventually. But the paragraph 16th has a sentence that has to do specifically with school buildings, and then a much broader sentence about protecting the safety of school children, right?
Right, and looking at the statute itself, and even the cases cited, that the statute is divided into parts, and each paragraph deals with a separate enumerated power given to the board. In fact, this seems to be the only part where the subject of power being given to the board is separated into two things. One has to do with the buildings. It doesn't actually read harmoniously as the state would have you believe it. Each part of that statute gives a separate enumerated power to the board. This seems to say, well, they have the authority.
Except for the last one, which talks about what's necessary.
I believe
which almost reads like the necessary and proper clause of the United States Constitution.
It does, but it
We'll
doesn't
talk about that
convey-
one later. Let's talk about paragraph 16th first. Why doesn't that give the board the power?
Because the sentence as read, which is, the board shall establish minimum standards for all public early childhood, elementary, secondary, and vocational technical school buildings, subject to the state provisions of the state building code. The board shall establish standards to ensure that every student shall attend classes in a safe environment. That should naturally be...
So let me ask you a hypothetical. Let's assume there was an old school building that had a lot of lead paint and asbestos in it, and the town or the DESE decided that the best way to protect the students in the school from the tiny particles of lead paint and asbestos was to require them to all wear masks. Under your interpretation of that language, could they do that?
No, Your Honor, and again, because I don't think that has to do, that's them issuing a public health measure versus them enforcing enforcing the local building codes or the state building codes is different. And so what happens...
So they could require the town to take out the lead paint and the asbestos, but they couldn't do something to prevent the kids from being exposed to it?
Well, right, Your Honor, and they actually did that in South Hadley, and that was part of the trial record. In fact, that exact, we're not even challenging the exigent circumstances. They did that exact thing in South Hadley. There was mold covering the school. The state created a remote learning plan and ordered essentially South Hadley to rectify the mold issue. So they were given a certain amount of days to engage in a remote learning plan, fix the mold issue, and then the students could come back to school.
Why couldn't they just have the students be in school with masks if they made a determination that under those circumstances the mask would be sufficient to avoid the mold problem?
Because if there's a mold problem...
Because they decide at the same time, as is clearly within their power, that it's more important for the students to be in-person learning.
Right, but at the same time, Your Honor,
So your position would be that they couldn't reach that conclusion?
yes, Your Honor.
They could not reach the conclusion that it's better for the students to be an in-person situation in Justice Grant's mold hypothetical. It is without their power.
And I think it's not without their power to decide whether the students should be in person. It is still within their power, even within that statute, to make the school rectify the state sanitary code issue.
Right, but in the meantime, that could take months, that could take gosh knows how long trying to figure that problem out, right?
It could.
And the board, it's without their power to say, well, we've got an interim process. We're going to put masks on the children, and that's going to solve the mold problem at least sufficiently so that they can be in school together. Can't do that.
Well, no, Your Honor, not if it's a public health measure. And I think two things about the instant case here.
How are we to determine that? Sounds like an education measure to me because it's motivated by an educational determination that it's better for the children to be in school. How are we to figure that out? That you say, oh, it's public health. That sounds like Ipsy-Dixit to me. Is there some case? Is there some standard that tells me that's public health and that's education?
No. In fact, there's no cases on point that one grant as much authority as the state is claiming they have. In fact, the cases cited, most of them refer to the state's ability under the Education Reform Act to enforce a specific provision of the statute. Here, the local boards of health are given authority to keep kids out of school for certain reasons. They're given authority, the local boards of health are given authority to require vaccination of their citizens. There is actual legislative authority vested in local boards of health.
But don't the local boards of education have, well, we're not talking about local boards yet. Don't the state boards of education have the power to act to ensure the safety of the students? You would say no?
I'm not saying no, I'm just saying
Can they mandate, for example, metal detectors in all the schools?
So I'm not saying no, I'm just
The
saying
answer to that question.
Well, Your Honor, to say no, they can't ensure say the word safety is as much of the Hixie-Dixie as the public health.
No, it's not, actually. I think safety goes back hundreds of years as being a police power of the states. It's like one of the most fundamental words in our jurisprudence is ensuring the safety of the citizens. So let's talk about safety. Could the state boards of education say, we're going to mandate that you have metal detectors in the schools because we're concerned about people bringing guns in?
Yes, Your Honor.
Okay,
and I actually believe my brother's brief addressed a case with respect to, or it may have been briefed in one of the school boards, with respect to a student who brought a lipstick knife in school. That's a very clear-cut safety measure. They had to implement certain policies with respect to that student bringing a knife to school.
So what I don't understand is how we're going to draw the distinction between that kind of safety measure and a safety measure that says you need to wear masks because there is a deadly virus that's out there right now. We need to deal with that.
And I don't think that's even before us. The policy said you have to wear masks until you reach a vaccination percentage within the schools, and then the students who are vaccinated can remove their masks.
Right. But how does that, I don't understand how that's responsive to my question.
So with respect
I might be missing something, so educate me.
Right. I guess I don't, and maybe I'm not understanding the question either. The statute gives a specific authority to the school.
And are you saying that it's not in the discretion of the DESE, that's the agency that construes the statute, to construe those words safe environment to include public health measures such as masking?
I am, Your Honor. With that, I've gone over time for
Well, if you don't mind, since we only have two cases and you're standing there, I'm still stuck on, if you don't mind, the question of, we haven't had a mask mandate in almost a year in any school in this state, right? So what are we doing?
the mootness issue, right? So
Yeah, what do we, exactly, the mootness issue.
Right.
What are we doing other than an intellectual, and an interesting, perhaps, intellectual exercise, but what are we doing?
So the two issues, Your Honor. One, I believe the issue is not moot, given the factors I tried to distinguish in my brief from Morrell. I won't go through incredible detail, other than I do think there is a certain distinction that can be made with respect to Morrell, where the city was granted the preliminary injunction, the appellant appealed, it was the city arguing mootness. It was the city who would have had to go on through getting a whole nother injunction. The capability of repetition, the board still has this regulation in effect. They still have, they still could at any time say, yes, we can just implement
That goes more to why should we decide this despite its mootness, though, right?
And I think a couple things. What was sought was not just an injunction.
Before we get there, so we can all agree it's a moot issue, but we can't enjoin something that doesn't exist.
Right.
Okay.
We can
All
still
right.
decide.
So then the
case.
question is, why are we deciding it? And again, talk to me about why this is less speculative, that the state would reimpose a mask mandate under the current circumstances, whereas at least I understand it, even as a national emergency, it's over in a couple months, according to the president last night, as opposed to the governor reimposing a statewide mask mandate.
Well, the regulation in and of itself, Your Honor, doesn't require a governor's emergency, that the board can essentially declare exigent circumstances. So the power still remains in effect. And I think that likens towards the Roman Catholic Diocese case where the governor, he changed their zone, but at any point in time, he could just put them back into his zone. And the court did mention essentially the time it would take to get relief. I know the state defendants had argued that, the courts can process these expeditiously, but if we look at the time frame from this case, I think it was almost 5 months or more before the single justice rendered his decision. That's a significant period of time for people to come back into the court and get recourse if they decide that there's an exigent circumstance tomorrow.
So are you suggesting that the SJC got it wrong there, that they said, well, we're pretty agile and we can do things quickly, but look at this case, we really didn't? Is that your point there?
No, and I think that's why this is distinguished between Morel, because again, the state had. The state is the one who would have had, or the city of Lynn, rather, is the one who would have had to reapply for the injunction. It would have been the recipient of the injunction who would have had been the benefit of the time.
Yeah, but that wasn't the reason. I mean, their reasoning was, well, we can do these things quickly. It's not like a pregnancy, which is of limited duration. It's not like a Section 35 or a 7-8 commitment hearing, which, talking in sometimes a month and it's done, and so, well, what are we doing here, right? Or even, I think Justice Englander's opinion that dealt with DCF and in video conferencing, that, you're talking about 72-hour hearings there. It's a different animal, it seems to me, right? I mean, we can, well, that's a rhetorical question, so I'll leave it at that.
Well, why isn't this a job for the legislature? By asking us to exercise our discretion, you're essentially asking us to anticipate what the next variant would be like, how communicable it would be, how deadly it would be, and to decide what the state or the towns can do in response to that hypothetical variant.
Certainly, and I think Your Honor is right. I think the legislature, one, if they wanted to grant this specific power, they could have easily done that. They could have easily acted at any point in time, and then I think this is an issue for the legislature. If they did want to convey this specific power, I mean, like I said, they conveyed the power in the local boards of health to be able to issue a requirement that all of its citizens be vaccinated, and that goes back to the Jacobson, versus Massachusetts case. The legislature could have given this specific authority to the board, and our position is that they did not.
Thank you. Mr. Unger?
Members of the panel, may it please the court, my name is Brian Unger. I represent Children's Health Rights of Massachusetts, Inc., a nonprofit organization of parents and students that are opposed to the imposition of various COVID-19 related mandates in schools. Here, of course, being forced masking. Attorney McLean covered essentially our arguments for DESE's alleged lack of authority. What I do want to focus on here today is the lack of statutory authority for the individual districts, the school districts. And
where he takes a position opposed, almost diametrically opposed to yours, and says, yeah, there is authority in the local districts.
If that is the case, Your Honor, I would disagree. I don't see any clear independent statutory authority to create health rules for students.
Who does have the authority then? Just the Department of Public Health? Is that your position?
Or, well, just the way it happened.
You have a police power. I mean, let's just go to sort of the fundamentals, right? The police power resides with the states, right? States have the power to delegate that to their constituent parts, right? Am I right so far?
Correct.
Constitutionally?
Correct.
Okay, I thought so. So who has the power to decide how to make the students safe in schools under your view of things? Because you say the state doesn't have it, and then you say then you say the local boards don't have it.
So I want to draw the distinction between safety measures that the school districts can take and health measures which are not enumerated in the statute. And that would be General Law 7137H. It doesn't mention health anywhere. One case, as Attorney McLean...
I mean, so, like, when I went to school, and I imagine it's still the case, there was a school nurse, right?
Correct.
Illegal, apparently? School board doesn't have the power to hire the school nurse?
Your Honor, well, in fact, the school nurse, I believe, even under statute, has some authority to send a sick child home. The key difference being there that we are
I mean, you say there's a difference between safety and health, and I'm sitting here going, I can't find the distinction. So I'm trying to, I mean,
sure.
Schools have always taken care of the kids' health. That's part of what they do, isn't it?
From the perspective, well, okay, so there are statutory sections, as I acknowledge, where a school board could order a sick student to stay home. The school nurse could send a sick student home. But
They can't say, rather than going home, we think it would be sufficient for you to wear a mask.
Well, the key difference here is that the kids who are wearing masks are not obviously sick. So it's a preventative health measure that is being imposed on every student, regardless of whether they're sick or not.
Right, but why doesn't the local board at least have the power to reach that conclusion, that that's the way to do things?
I think a comparison could be drawn. Could the local boards require students to, take certain vitamins to prevent health crises?
If there was a head lice outbreak in a school, could the principal and the school nurse say that everybody with long hair has to wear a ponytail?
If that was responsive to lice, Your Honor, I'm not sure. In as much as that is a health-based regulation, I mean, probably, but I think here we're dealing with a unique situation. It's school boards attempting to respond to an infectious disease, an airborne infectious disease. And frankly, the cases that deal with safety, and which in particular, which has been widely cited throughout this case, which is Doe versus the superintendent of the schools of Worcester, as Attorney McLean pointed out, that was a case where a student was expelled for having a lipstick knife on school premises. And the language in that case is tracked directly back to the statute. That's Chapter 71, Section 37H, specifically prohibiting students from possessing weapons on school premises, giving the principal authority to expel a student if a student is found with a weapon. Similarly with drugs, fighting, violence on school premises. These are the things I believe that are traditionally encompassed by the statute. And the other cases, Dowd versus Dober.
But, I mean, if you're going to talk about traditionally, your brother points out that it's over 100 years ago that they had to deal with the problem of vaccinating kids before they came to school. That's kind of traditional too, isn't it?
And Your Honor, yes, but in the cases where that is the case, it's not the school district that is ordering vaccination. There are two cases that came up, Nichols versus Mayor and School Committee of Lynn, which cites the Hammond versus Town of Hyde Park, which stands for the assertion that school districts can enforce health rules, but in Hammond versus Hyde Park, the district was not the one that created it.
So are you suggesting then the state does have that authority? If the school districts don't, the state does have the authority?
I would say certain arms of the state, including the Department of Public Health, do. Okay. And in fact, I do believe there is a problem in 603 CMR 27.08 in giving DESE the authority, or rather DESE giving itself the authority to create health rules. It's just, that's really the first instance that we see the word health come up in the.
And it says the board shall issue health and safety requirements.
Correct.
It's pretty broad language.
Correct.
And again,
but-
we keep circling back to it, but why is a hat for head lice perhaps okay, but a mask for COVID not okay?
It's not as extreme of a measure, Your Honor, and I would argue that a hat for head lice, if that is something that's well researched, if that does actually stop the spread of head lice, okay.
But that's a different argument, okay? You've just shifted from an argument about authority to an argument about efficacy, to an argument, your argument about masks is that it's irrational. That's a subsequent argument, is even if there were authority, it's an irrational imposition of a rule, right?
I would say if there is any support that forcing school children to wear masks all day is actually hindering their ability to learn and is hindering, their educational goals, then in fact, these departments are going against an express duty of theirs, which is to ensure that they receive an
But one of their
adequate
duties,
education.
another one of their duties is to make the determination as to what's the best environment for them to learn in. And if they make the determination the best environment for them to learn in is to be in person in the schools, and they also make the determination that there are a whole lot of people who are going to have health risks if they go into the schools without masks on, not just the kids, but the teachers and the grandparents who are home when the kids come home to see their grandparents. I mean, isn't that exactly what these people are elected to do? Make those decisions,
I
weigh
believe that's-
those concerns.
It's a part of their authority, Your Honor, I would argue. But it's really, their main purpose is to administer the schools, is to administer educational programs.
What about my hypothetical about about metal detectors?
I believe that relates directly.
That's within their power, right?
I would agree, Your Honor. Yes,
Okay.
that directly relates to student
So
safety.
we're concerned about the kids being shot, but not about what might happen to their grandmother if they get COVID and go home?
I think it's a little more of a nebulous concept, just when it comes to wearing a mask with COVID.
Let me ask you a question. Did you appeal, you had a separate case against the city of Cambridge?
Correct.
And
Well, they were named in, I believe, what's been called the Norfolk complaint.
but you had sued, all right. What I'm trying to understand is is there a separate appeal taken as to the city of Cambridge?
A separate appeal, no, regarding the vaccination?
No.
I'm
I
sorry,
see
Your Honor.
nothing in the record whatsoever that suggests to me that you have standing to sue the city of Cambridge,
I see.
all right? And so I don't know why we even have them here or we have a brief about them unless somehow maybe you're suggesting they were just pulled along as a separate defendant?
No, I think inasmuch as the city of Cambridge's order related to the school districts or applied to schools or school children, inasmuch as the.
In order to have
Cambridge-
standing to sue the city of Cambridge, someone within your association had to suffer harm from something that the city of Cambridge did that you were complaining about, right?
Mm-hmm.
Was there anybody?
Well, the students.
Was there
at-
anything in the record that suggested that any person within your association suffered harm from what the city of Cambridge did?
What's alleged in the complaint, Your Honor?
Which is nothing with respect to the city of Cambridge, as I understand it. So why would you pursue a case under those circumstances? And when we have a request for attorney's fees, why wouldn't we grant them?
Well, Your Honor, first, I would respectfully state that the city of Cambridge did not make that request. On that request,
Maybe
Your
that's
Honor,
the end of the story. I understand that answer. You've gone over time, so.
If I may just briefly address the attorney fee request, Your Honor, in the 1 month roughly that I appeared on this case and filed the brief, if there was some case that I got wrong or something in the record that I got wrong, it was not It was not in any intent to mislead the court. So I would just ask that, that be denied.
I understand that point, counsel. There's a separate point that's made, though, as to whether the argument itself just has no reasonable basis in law when it comes to the local boards. Anyway, that's something for us to sort out. Okay?
Thank you, Your
Thank
Honor.
you.
Good morning. May it please the court. Richard Weitzel, Assistant Attorney General for the State Appellees. I was hoping to first discuss the issue of mootness. It's certainly our position that this appeal is virtually indistinguishable from the City of Lynn versus Murrell case. I think Justice Brennan is absolutely correct. It really boils down to the exceptions to that doctrine. The case is clearly moot. The questions are moot. In both this case and the City of Lynn case, it's essentially the same facts. A mask mandate had expired months ago, and the argument is that, well, it's possible that the mask mandate could be reinstated at some future date.
Isn't that quite a plausible argument, counsel?
It's undeniable, Your Honor, that it is possible that it could be reinstated. That's not the standard that's set out in the City of Lynn case, which is the issue is the mandate certain to arise, or at least very likely to arise, and in similar factual circumstances. And that just doesn't fit the case here.
There are differences from City of Lynn. Let me just ask this. The state doesn't want us to decide this? That's what I'm understanding your argument to be?
That's not, I don't think that's a fair characterization.
If you thought you had a good argument, you might want it to just be decided, so you don't have to deal with it again. If we say it's moot, then you're going to have to deal with it again, because there are people who don't think masks are a good idea.
I understand Your Honor's point, and certainly we are very confident in the legal arguments we're making, which Justice Ditkoff adopted and accepted. Really, as I hope the court appreciates, we're really respecting the principles of judicial review and the fact that there should be a live controversy in play.
But some of these questions are just pure questions of law. Does the State Board of Health have the authority to issue this requirement? It's basically a pure question of law, right?
I don't deny that, Your Honor. I think the same was true in many respects in the City of Lynn case. There were questions of law. In that case, it was whether the executive orders were preempted by OSHA, essentially a question of law. I do think that, it really boils down to, does the case fit these two prongs of the exception, certain or very likely to occur, and likely to...
You think we got it wrong in Thaddeus to decide to go forward and decide that issue?
Not at all. I mean, I think Thaddeus is readily distinguishable from
How would you
this case.
distinguish Thaddeus?
So in two respects. And first of all, that case involved a very sort of time-defined transitory issue involving child visitation. And as the court pointed out, there was still an element in that case of an ongoing action by the government. I think that the court pointed out that DCF, there was still some element of virtual visitation that was ongoing with DCF. So
I think that's fair. I think that's fair. And as you know, I have some knowledge of the case. But,
yes.
The original order from the State Board of Health in this case lasted for 36 days. It was supposed to start on August 27th and end on October 1st. And if it had, there would have been no opportunity for judicial review of the original order, right?
I don't agree with that, Your Honor.
Think that we could have got our court, or you think we could have got our court spun up in 36 days? Especially giving some time for the trial court to make a decision?
Well, a couple things. I think there is a way to streamline appellate review by going to the SJC, for example.
The SJC could have done it in 36 days.
Well, Your Honor, in the Goldstein case, which was, I think, in like March or April of 2020, that case involved a COVID issue relating to nominating petitions. It was election-related. In that case, the case started and finished within about 9 days, including full briefing and a decision. I understand that's an extreme situation, but I think the SJC...
Because it was filed in that court, right? The case was filed in the SJC. That's not what's going to happen with these cases. They're going to start in a trial court. But I take your point. I take your point.
Okay. The last thing I'll just say on mootness, Your Honor, is that the City of Lynn case doesn't by any means stand alone. I think, notwithstanding Thaddeus, which I think is a unique set of facts, there's really a string of cases. SJC, this court, the Avila case, which relates to the City of Boston eviction moratorium, the Town of Oxford case, which we attached to our brief. Also, the First Circuit has really taken this approach in a couple recent cases.
All right. Can we switch to the merits for a moment?
Yes.
They have an affidavit from a professor at Brown with 30 years' experience that says masks don't work. And here are 13 studies that show that masks don't work. What's the response to that? Because honestly, I had to read pretty deeply to find any.
Are you referring to the response in the record to that, or?
Yeah.
Well, we do have an affidavit from the Director of Infectious Diseases at the Department of Public Health who opined that masks are effective. There's a letter in the record from about 300 physicians that endorse mask wearing.
But what's the response to here are 13 studies that show that masks don't work?
There are certainly counter studies, Your Honor. In fact, there was just one it may have been a mere weeks ago that New England Journal of Medicine, there was a study about what happened when this particular mask mandate was lifted, and there was an uptick.
Okay, so that's not in this record.
That's not.
I'm harpooning you a little bit, and maybe unfairly, but I think actually no. I mean, when you have someone who comes in and says the rule that's been adopted is irrational, and here's 13 peer-reviewed studies that indicate that it is, I would expect to see something in your record that says, here's why he's wrong. And it turns out the best I could find, and it's really pretty good, is by a circuit court judge in Florida who spent the time to go through those and explain why they're not really that good, and that in fact there are about 6 or 7 studies since then specific to COVID that indicate that masks do work. It's just, it seems to me that that's part of the core of the reason that these people were in court, right?
That may be while they're in court, but I think, Your Honor, the law is very clear that rational basis does not rely upon sort of some demonstration relating a fact or empirical evidence. It has to simply be reasonable. So there was a very good reason why there's not abundant.
What would be the reason it would be reasonable if you didn't have empirical evidence to rebut their expert?
Well, for one thing, the CDC, the most authoritative body in the United States, was endorsing mask wearing in schools at the time that this mask mandate, and that is cited, that's a matter of public record. There are countless American Academy of Pediatrics, many organizations endorse mask wearing, including in schools. This was, but again, that's not the legal test of rational basis, and the Supreme Court of the United States couldn't be clearer on that point. I'm not running away from the facts on that because again, I think the
I'm
department's
not
entitled.
sure that you're right that that's not the test. I mean, I think if you're going to make a decision about a health mandate, that you would want to know what the experts say and sift through that that's the way to be rational. And simply saying, well, yeah, there are 13 studies that say they're no good, but over here, somebody thinks they're okay, so that's good, we're rational?
Well, that's, with all due respect, that's a mischaracterization of what the board did here. The board did consult with health professionals. They consulted with the Department of Public Health, which is the authoritative body when it comes to infectious diseases, and they made the decision based on those consultations. That's discussed in the Madoff affidavit that we submitted, how these two agencies did speak with each other, and certainly the Department of Public Health was taking some guidance from the CDC. So this was the last thing far removed from sort of a random decision.
Well, the Madoff affidavit does cite that one Arizona study, which at that time that this was done was public. I think your time is up, so thank you very much.
Thank you.
Mr. Mello.
Your Honor. Members of the panel, thank you very much. Peter Mello, Murphy, Hesse, Toomey, and Lehane, on behalf of the school district defendants. May it please the court.
Could you speak up?
Oh, sure. Sure. May it please the court. So when DESE lifted its mask mandate, it recognized what explicit statutory authority, axiomatic case law, and ordinary common sense dictate, and what even the co-appellants acknowledge, that Massachusetts school districts wield independent authority to impose mask requirements. And a similar crush of dispositive and categorical legal authority also forecloses their constitutional challenge. And on those grounds alone, a court could dismiss a complaint altogether and much less deny a motion for a preliminary injunction. So let me address each of those points in turn, beginning with the former. As the single justice, Justice Ditkoff, concluded, and as we've addressed in our papers, numerous provisions of Chapter 71, including 37, 37H, and 68, confer explicitly upon school districts broadly the general charge and superintendence of school buildings and the ability to regulate matters of safety therein. Numerous decisions of the Supreme Judicial Court have recognized that power is broad. They've characterized
Word
it
health
as broad.
doesn't appear in any of those?
I'm sorry?
The word health doesn't appear in any of those explicit authorizations?
In Chapter 71, well, that's a distinction.
No, I'm just asking, is that right? The word health doesn't appear?
In 37, 37H, and 68, I'm not sure. I don't have a memory that the word health explicitly
safety
appears in any.
appears?
I think safety encompasses within its scope the ability to regulate matters of health. It's a distinction without a difference, as Your Honor pointed out during my brother's presentation. Look, I'm at a loss to explain how they could conclude that the explicit authority isn't conferred in those sections. The language couldn't be clearer in each of those sections. And moreover, again, the statutory scheme...
I suppose the argument comes from the notion that that what schools, if you want to talk about what they do at their core, they educate students. They're not police officers. They're not nurses, right? That's the argument, basically, that what you guys are responsible for is education. And there's someone else who's responsible for health, i.e. the Department of Public Health and your Board of Health. What do you say to that?
Well, first of all, obviously, as the record reflects, DPH was intimately involved with DESE in connection with formulating these requirements, as were local boards of health involved with local
So
school
they would say, fine, but why didn't this come from your Board of Health?
Well,
The
again-
Town of Andover's Board of Health, for example. Why aren't they the ones who decided the kids should be wearing masks?
Right. In many cases, as a practical matter, they were working intimately with schools in formulating these requirements. But again, these provisions in Chapter 70...
If they were the only ones with authority, they can't just delegate it to the schools, right?
Well, I think Justice Ditkoff addressed this explicitly in his decision in relying on the Desroches case. The SJC has concluded that there's no preemption with respect to this issue specifically. That's more of a preemption argument. Numerous provisions of Chapter 71 confer explicit authority upon school districts to protect students' health and safety, and it's common sense, right? I mean, the whole impetus behind the entire statutory scheme was to serve the best interest of the students.
The argument, it's common sense, that works sometimes, but in the context of having authority by statute, it doesn't work very well. It's got to be there.
And it is. It is explicit. And if you know, the language is in our papers. Happy to go through it if you'd like. Within, you know, the limited time we have, I would just, I guess, focus more broadly on the concept that, look, the SJC has affirmed in multiple decisions that the power of local school districts to regulate matters of health and safety within schools is broad and ample, including with respect to the ability to protect students from the risk of exposing other pupils to contagious disease. Neither before the Superior Court, the single justice, nor this panel have the appellants rebutted virtually any of the case law to that effect, and they've eschewed it essentially entirely in favor of this myopic, respectfully, and flatly erroneous legal proposition that school districts wield only that authority that the legislature has explicitly prescribed, you know, or enumerated as if in some paint-by-numbers instruction manual. Their own case law forecloses that proposition and underscores among the most axiomatic tenets of Massachusetts municipal law and governance is that municipal regulations are presumed valid and will be invalidated only where they conflict with the Constitution or a state statute. They'll only be deemed to conflict with a state statute where the legislature has expressly foreclosed local regulation, or where a local regulation so frustrates a state statute that essentially the legislature is construed to have preempted the field. Courts reach those types of conclusions sparingly and in the scarcest of circumstances, and those at issue here don't remotely suffice to compel that sort of a conclusion. There's really no plausible argument that school districts don't wield this authority independently. With respect to the constitutional argument, which, you know, with all due respect, I think is baseless, and, you know, being mindful of our time allocation, I won't belabor it, nor do I think it really suffices to warrant more than perfunctory or passing attention and treatment. But with remarkable unanimity, courts both within and outside of Massachusetts have recognized that neither the state nor federal constitution empowers parents to infringe upon a student's authority to protect its students from the rampant spread of a contagious disease. And as you utter the words, it's almost a self-evident proposition. And I'm sure it's not lost, I know it's not lost on the panel, but I guess I'd be remiss if I didn't underscore that what we're dealing with here is a decision on a motion for a preliminary injunction with respect to which the appellants didn't remotely satisfy any of the required elements, including with respect to, you know, likelihood of success on the merits, a showing of irreparable harm, and that the requested relief was consistent with the public interest.
Okay. Thank you. We have your argument. Your time's expired.
Thank you, Ryan.
Appreciate the arguments of all counsel. Case is submitted. Next case is an impounded case, Department of Children and Families versus a father. (22P 487).
Good morning, Your Honors. Attorney Lina Garuva-Wilson, on behalf of the father. May I begin?
You may begin.
So, at its core, this is a matter of disagreement between my client, the father of a 9-year-old disabled child, who believes that this child should be raised at home, and the department, who believe that this child should be raised at an institutional school, and be home only with her father on the weekends and holidays. Now, Again, this is clear what happened here. This was the judge who was trying to find a practical solution of a problem of money. Now, my client was found to be fit to
I read the opinion specifically for that purpose, because that was a focus of your briefs. And I didn't really see that. I saw a judge trying to resolve a problem of whether or not the father was capable of caring for a child with extraordinary special needs. So what do you point to that shows that this was about money?
The judge several times stated that the child needs 24-hour residential care and that she will regress if she returns home. And this is the problem. There was no expert opinion that stating that she will regress. This was a prediction that was not within the purview of a lay witness. And the judge mentioned 22 times, I believe, in his opinion, the opinion of that layperson who was not introduced as an expert witness,
Well, you say
that
it's
she
an
will regress.
opinion, but she was the personal clinical help to the child, right?
Yes, Your Honor. She was able to testify as to...
And so she has observed the child's improvements
Correct?
and is intimately familiar with where the child started and where the child was as of the time of trial.
Correct?
You think that she, without being qualified as an expert, but based on her observations, is not able to say, I am concerned that if the child is no longer going to be doing what she's been doing with me, that she will regress?
The answer, Your Honor, is that she's not. She can be concerned. However, the judge took that concern and elevated it to the level of expert opinion, and that is where the error lies, because there's absolutely nothing to suggest that she will actually regress. Actually,
Can I ask you a question on that? Excuse me.
Yes.
Did you have your answer? I'm sorry. Do you want to complete your answer? I apologize.
No, I just wanted to mention that there was absolutely no evidence she would actually regress, and the evidence suggested otherwise. She did well in her weekends with her father. She came back happy. There was absolutely no concern stated, and the stating that she would regress is speculative at best.
So my question is, do you take issue with the fact that she was not technically qualified as an expert, or is it your position that she certainly didn't have the, at least on the record, background, training, and experience to offer that sort of an opinion?
I'm not concerned so much with whether or not she could have been qualified as an expert, but if she had been disclosed as an expert prior to trial, which I believe was the judge's order, father's attorney could have found a rebuttal witness and could have been more effective in cross-examining her. But since she was not offered as an expert witness, she didn't have that opportunity to present
So it's more of a,
expert evidence.
I'm sorry, it's more of a discovery and fair notice issue and not so much a qualification and probative value of her testimony.
Correct, and also, again, her opinion was based on not only incomplete evidence, but in no evidence what would have happened.
Can't the juvenile court judge draw an inference from the evidence about what might happen in the future? The same way the juvenile court judges do all the time with the amount of drug treatment someone's had. They draw an inference about whether or not it's likely that they'll relapse in the future. Here, there's evidence that this child improved with this intensive, round-the-clock supervision and treatment at this special school. And can't the judge herself just infer, or himself, I think, infer from that without those supports, the kid would deteriorate or regress?
Well, I agree with you that, I mean, it is well established that the judge can rely on pattern of behavior. However, she never regressed in father's care. It was pattern of her regressing in a program, in different placements. So to answer your question, no, under those particular circumstances, that conclusion cannot be drawn because it is not based on father's parenting of this particular child. In fact, he parented her from birth until age 3, and she wasn't removed at that time. So
You'll agree, though, that there's a difference in, I mean, but children between 0 and 3, the
Mostly nonverbal.
emotional and developmental concerns are not as significant as when they're teenagers or when they get older.
Yes, Your Honor, but let's not forget that this child actually had an IEP, individual educational plan, that had numerous supports in place, which father could access had he had custody. He wanted to place her in a day school, as the IEP allowed for. He wanted her to have in-home services. I believe she could have up to 20 hours. And he was parenting only her. The plan was for him to be parenting almost exclusively her by himself without his other children present. So she would be having one-on-one attention to begin with.
Did anybody?
24/7?
Well, no, not 24/7. She would have been at school, Your Honor, and during the week, and then she would have at-home services, and he would be alone with her during the night, and he would wake up several times at night to keep an eye on her.
As I understand it, part of father's concern is that he wanted some sense of normalcy for his child, wanted to be in a regular school, if you will. Is that fair?
Yes, Your Honor, that
Is
was
there
part
any
of it.
evidence at all that she could function in any even remote way in a public school or a school that may have an IEP or have special services, but isn't the same intensive type of care that she was receiving?
Well, I'm not sure I understand the question. If there's evidence that she would function well in such school?
Yeah.
Well,
Yeah.
the
I
school
mean, if his idea is, I
department
just want to send her to a school up the street, because I want her to hang out with regular, kids in the neighborhood. Any sense at all that that's even remotely realistic?
So the evidence to support that is that her IEP for several years, for 3 years, included specialized day school, and the father didn't want her in the regular school. He wanted her in specialized school as provided by the IEP, and he took the word for the school department for it. The school department believed that that's where she would
The school
thrive.
department wasn't ruling out a residential placement, as your opponents point out. All the school department was doing is what they're supposed to do, which is determine what her education should be, and the education should be specialized.
So
I don't understand it to be ruling out a residential placement.
I respectfully disagree, Your Honor, in terms of what they're ruling out, because the school department is the one that pays for, this was a school. This was a residential school. It was not nursing home. And that's why they're obligated to pay for, the IEP would have been, the school department would have been obligated to pay for her care if they believed she needed residential care to thrive academically. There is no other institution.
Right, but what,
that
weren't they splitting the costs with DCF? Isn't that what they're doing now?
They were
School
splitting.
department pays for the schooling and and DCF pays for the residential. Isn't that what's happening?
They were splitting the cost, yes, and the judge and everyone else made clear that if custody was returned to father, he won't be able to afford that, and that was the whole problem. Because, as I said in my brief, you cannot, financial conditions cannot be basis for finding of unfitness, and now that's what happened here. I mean, had my client said, I do not want her in an institution, but if you believe that she'll be better off there, I'll keep her there. I would like custody returned to me, and I'll pay for it. Would the decision been the same? I'll submit to you it wouldn't have been, because everybody's concern was keeping this child in that program that a father couldn't afford to pay for. And again, I do believe that this is a matter of
And this was where we were, we've returned to where we were at the top of the argument. What do you rely on to say that that was the judge's motivation or primary or one of the primary motivations? What do you rely on?
The judge's words, Your Honor, yeah, I have cited it in my
The
brief.
judge's words where? I've got the thing out. Point me to him.
I cited it in my brief, I don't recall each page, but I will remind you what he said. He said something to the effect that I owe it to you and your child to review all the evidence and do what's best for you and your daughter.
That's not a finding, that's a statement at the end of trial.
Yes, I'm not referring to the finding of facts or conclusions of law.
But that's where I'd like you to refer me. If your argument centers on the notion that the error of the judge was that he made his decision because the father couldn't pay for a residential placement, where did the judge say that?
Well, he didn't. He did not say that he cannot pay for it, but he made it clear that the department won't do it. And it's, to me, it is clear that it's a matter of money.
Made it clear that the department won't do it?
So the judge stated that if the child is returned, if the custody is returned to father, the department wouldn't pay for the residential treatment. Why does it need to be even mentioned if the judge is not relying on it? And even, let's say that there's enough evidence that this child
I
needs
mean,
this
wasn't
level
the
of care.
judge's, the way I read it, the judge is trying to decide whether the child can be returned to the father's custody, with the father to make the determinations with respect to education, and having to care for the child when the child is not being educated. That was the nature of the testimony that the father gave. And you have these, the court is concerned with father's understanding of child's needs at this time. I mean, that's a finding, right? It's repeated multiple times.
It is repeated, Your Honor, but the judge also said that her needs can only be met in a residential placement, and this is what is troubling, because without anybody paying for it, anybody else being in a position to pay for it, father's inability to do so himself is inevitably being held as a reason for his unfitness, and that cannot be a reason for that.
What if there was a situation where the father, let's say the father was a trained social worker, and the father's spouse was a pediatric nurse, and also living with them was another family member that had experience dealing with children with autism. And the father said, we can handle it. We can take care of this kid 24/7. We have this specialized expertise. Would it be fair for the juvenile court to rule differently in a situation like that? Are they discriminating against your client because he's a single father?
I do believe the judge might have ruled differently. Obviously, I do not know if that would have been the case, but this particular judge said she does require this type of treatment.
So I guess my thought is that the standard for unfitness is about whether this particular parent is unfit to parent this particular child. It's not saying he's unfit as a father in general or for all purposes. If there were a child with different needs, he might well be fit.
Correct, Jon. I don't disagree with this premise. However, if we look at the evidence, what those needs are, other than the school day, where she'll be going to a dedicated school for children with autism to begin with. Other than that, what are the needs that were articulated that she has? Her hair needs to be tied back. Her food needs to be cut up. She needs to wear light clothing. She needs to be prevented from running away if she attempted to run away. I mean, there's no evidence to suggest that this father cannot do that.
Well, wait a
Isn't it a
second.
lot harder to control some 10-year-old that's having a tantrum than it was to control a 3-year-old when the father last had full-time care of her?
It conceivably might be, but that would be shifting the burden of proof on the father, that he is able to care for the child, and the judge even held the fact that the child didn't have tantrums when she was in his care the last several times that they had sleepovers. Held that against the father, which was unfair because it was impermissible shifting of the burden of proof on him that he can meet those needs. And
Well,
again, there was nothing to suggest that he couldn't.
The court finds that the child remains a child who requires attentive supervision 24 hours per day, right?
Correct?
You say that that's clearly erroneous?
Yes, well, no, what I'm saying is that she...
Yes or no? You said both.
Whether or not she requires 24 hours a day?
Yeah, is that clearly erroneous?
No, this is not clearly erroneous. There was enough for him
Okay.
to find that. However, it was clearly erroneous that the father, there was enough evidence for the father to be found unfit. In other words, that he cannot provide this type of supervision because she requires 24/7 care. How is he allowed to have her over the weekends? How is he allowed to have her anytime?
You're talking about
that he
4
wants?
days. In the record, that it happened on 4 days
It happened over 4 weekends,
prior to
yes.
trial.
Correct.
And so the judge is trying to weigh that and reaches the conclusion that I'm not yet satisfied that father knows enough about the child's needs, her medical needs, how he is going to take care of her 24/7. Isn't that what happened?
This is what happened, but again, the father didn't need to show that. It was the department that had to prove that he cannot, and they failed because what were the needs that were articulated? I mean, there were needs that he had been meeting already.
Your client's dedication to his daughter is really admirable.
Thank you. I'll relay that to him, Your Honor.
Can I ask another question about that? Was there anything in the record about the other two children of the father and how they were being
yes.
cared for?
Yes, Your Honor. He had a 1-year-old and a 2-year-old son at the time. They were not living with him, but they were visiting with him usually on weekends. And one of them he had brought to the program several times to introduce to his sister.
Okay,
And they were not subject to DCF care or custody.
I understand. Okay, thank you.
And again, Your Honor,
I'm sorry, I think your time has expired, yeah. You've done a very nice job for your client.
Thank you, Your Honor.
And we're going to hear from the opposing counsel now.
Thank you.
Mr. Cuttle?
Good morning, Your Honors. William Cuttle for the Department of Children and Families. We're asking the court to affirm the trial court's decision in this case. I'd like to just point out, this is not the normal case that comes before the court. It's not a termination of parental rights case. As the court found in his conclusions of law, I think it's 30, the father has the right to come back to the juvenile court once every 6 months if his circumstances change, to have this case reviewed. And I want to point out, in reviewing for this oral argument, I read over the trial transcript again, and the judge who handled this case did a wonderful job of managing the trial. Father was well represented at trial as he has been here before you. It was a thorough trial, and this case comes down to what the court found in conclusion of law 12, which is this child has substantial needs that require extraordinary attentiveness. And I'm not going to go through all the findings that the court made. Just by listening to your questions, it sounds like you're very aware of her autism, her level 3 autism, and the difficulties that she has, the progress that she has made in residential level.
Counsel, I have a question. The father's counsel argues that it was burden shifting of the judge to, among other things, draw an adverse inference from the fact that the father walked out of a meeting at which he learned that there was no cure for autism and his daughter would have this diagnosis for life. Is that fair for the judge to draw an adverse inference from that?
I wouldn't characterize that as an adverse inference, Your Honor. I think what the court was, as he did in many of his findings, was pointing out evidence that father hadn't reached the level of understanding or acceptance or training to take care of his daughter.
Wow. Let me ask the question that sort of jumped out at me.
Sure.
Why is the father unfit? Just articulate why this father is unfit to care for his child.
I'll be happy to do that, Your Honor. As is set forth in the department's brief, fitness is not the mere absence of neglect or abuse. And that's this case. The father, because this child had extraordinary needs, the court is in the position of having to look through the lens of the context of the child's needs and what the father or parent is able to do for this child. In many cases, and as you know, I've been doing this work for a long time, the father met many of his service plan tasks. The court didn't duck anything in this case. I just wanted to make that clear.
But you haven't answered my question.
I'm answering your question. He did some.
I understand it's a hard question.
Well, no, it's not a hard question.
But it seems to me to be
Your
the
Honor.
most fundamental question.
Your Honor, it's not a hard question.
Okay.
He demonstrated that he was not able to learn what his daughter's shortcomings were. He didn't consistently visit with his daughter. He didn't consistently attend trainings or his IEP meetings. He wasn't able to.
You probably described some significant percentage of all parents in the Commonwealth of Massachusetts.
You're absolutely right. But this child is not the average common child in the Commonwealth of Massachusetts. This child has extraordinary deficits that require her to have this level of care. And, the word residential is used a lot, both in our community and in these cases, and it's a polarizing word. But I would ask the court to really focus on, and the court did this, using the term level of care. This child made progress in 3 years, slow progress, in doing some basic communication skills. She came into this program not being able to communicate, not being toilet trained. She was 6 years old. She's made some progress. It's slow. The court, with all the evidence that the court heard, both in testimony and the exhibits, considered all the evidence and determined that at this time, and Judge English, earlier when you were talking with appellant mother's counsel, you used the term "at this time." The facts of this case, that the findings made by the judge, are limited to this time. It's at the time that the court heard all the evidence. The court very graciously and I think respectfully, because the father was at every day of trial and he was participating, and the court even let him speak after everyone had given their closing arguments. He was very encouraging to file and said his father and sent out a roadmap of what he needs to do. But the court clearly found that he wasn't able at this time and wasn't going to place the child in risk of danger. As the clinician testified several times, this child does not have self-preservation skills. She used examples of not understanding she can't touch a stove, she can't run into traffic, things like that. The court wasn't going to take that risk given the evidence of her needs and father's, at this time, incapacity to meet her needs. He just didn't get to that point. The Lorna case has said many
Do you
times.
think that he was applying a standard different because it's a father rather than a mother?
Say that again?
Do you think the judge was applying a different standard because he was dealing with a father rather than a mother?
Absolutely not. There's no evidence to that point at all, Your Honor, and I can honestly say to you, after reading the trial transcript, definitively no. He was gracious and kind to this man. It had nothing to do with his gender at all.
Because I don't remember anyone ever sort of using as a basis to say that a parent is unfit when we're talking about a mother. Well, the child might be at risk because the child might run in the street and really didn't understand.
The judge didn't say that, Your Honor. The clinician said that at trial.
I know, but you're using that as a basis for saying that this father was unfit, right?
The court found him unfit at this time, Your Honor. He did. And he also acknowledged in his findings that the father did have 4 visits with his child at home, that the child was brought back okay. The court didn't ignore that fact or those findings, but he concluded after all the evidence that the father, in his opinion, in the judge's opinion, was not able to take care of this child on a day-to-day basis full-time at this time. The child needs 24/7 care. That's clear throughout the record.
Yeah, the judge actually did not find that she had to be in a residential setting, simply that she needed to be cared for 24/7, right? And that was supported by the evidence.
He didn't say that the child had to be in this specific residential program, but she needed residential level of care, Your Honor.
Okay.
And there's no, just before I have to stop, how much time do I have, Your Honor?
Your time's actually expired, but if you have something more to say.
I just wanted to point out that very quickly, that the department has an obligation, is required to find the placements for its foster children. The 6 findings that the father relies on, saying they're erroneous, as I set forth in my brief, there's evidence to support all of them. It's more of a disagreement with the weight of the evidence.
Can I, your opponent says that the judge's real motivation here was that the father didn't have money, and I pressed her on that. But let me ask this, because I want to just understand it.
Sure.
If the child were placed with father, then whatever school district the father resided in would be responsible for the child's education, right?
Yes, through an IEP. Yes.
Through an IEP, which would, in this case, almost certainly include very specialized educational services.
Absolutely, Your Honor.
Okay. And transportation to those very specialized educational services?
I don't have the exact answer to that question. I'd have to defer to that. I'm assuming an IEP's
My guess is yes.
Yeah.
I mean, but that'd be a matter of probably federal law in the first instance. Okay.
I just in closing, just rely on the department's brief and to really just remind this court that the father does have the opportunity to go back to the trial court to revisit this issue when he believes it's appropriate to do so.
Thank you, counsel.
Thank you.
Mr. Ferguson.
Good morning to the court, and may it please the court. My name is Hugh Ferguson, and I represent the appellee child. This is
Ferguson, I know it's not customary to not even let you get a word out, but before I lose the train, picking up on where co-counsel left off, with the father has the right to go back every 6 months.
correct, Your Honor.
In your brief, I note that you identify the father's cognitive limitations, his IQ, the fact that at some point when he was in care, they said he couldn't boil water, didn't know how to boil water, that he's bipolar, schizophrenic, PTSD, has depression, anxiety.
Correct,
So
Your
aren't
Honor.
we really, is that really false hope that the judge was giving, and are we really talking about a situation practically, if those are the father's limitations, where the department is basically, this is a
Absolutely.
permanency without permanency, without official permanency?
I would say absolutely not, Your Honor. One of the things and I think one of the things that I would like to bring to the court's attention is that this father had stopped taking medications 5 years ago. Were he to be taking medications, things may be different. He stopped going to therapy. If he were going to therapy, that might make things different. He is on a wait list for therapy, or he was on a wait list for therapy, and that might make things different. He stated, though, he did not want to see a therapist and he did not think it would be helpful. So I don't believe the court is holding out false hope, but the court did put a roadmap together of those issues that the court thinks are incredibly important for this father to do to be able to successfully parent this child. I'd say again, this is also...
I read the father's testimony, and I got to tell you, a lot of what you say did not come through in his testimony. The father's testimony struck me as quite thoughtful and responsive.
That's fine today, Your Honor, but how does that impact when he's parenting the child? And as...
There were no indications with respect to this father that when he was parenting the child, he had any issues. They gave the child overnight. He was fine, and she was fine with the father.
She was fine overnight on 4 overnights, Your Honor, and
That's all he'd had.
Again, if he had started earlier doing some of these things that happened towards the end of the case, he may have had more. You'll note from the record that the clinician said that she wakes up sometimes 3 nights a week, and he just happened to get those 4 different weeks when she didn't wake up, according to his testimony. And I'm not saying that he couldn't care for her when she woke up, but what I would say is that she is a child with level 3 autism. I attached the definitions of that with my brief. This child is not safe on her own in the community, and she has, outside of her bedroom in the facility, awake staff overnight to deal with these. And it's in the record. This is a decentralized program where the children go to school at this large complex, and then they're in separate homes in the community, approximately 10 minutes away. There is live, awake staff in that overnight. Who of us who's a parent would be able to wake up and deal with our incredibly impaired child?
Were you the person who represented the child at trial?
No, Your Honor, I was not.
Okay. One of the things that's difficult about these cases, for me, maybe for you as well, I imagine it is how do you decide which side of the V you're going to show up on?
I'm sorry, which side of the what?
Which side of the V you're going to show up on?
We were trained that we're supposed to represent, with a child like this who cannot state a position, what is in the child's best interest? And what would that child say if that child were to understand the global nature of what's going on with her, how her parent is able to care for her, and what it was that she would want? I would like to step back just a moment in history, though, and where opposing counsel said that she was with her father parented her for 3 years. You've seen in the record that those 3 years were very tumultuous. They were filled with substance use, with domestic violence, with parents who are not able to pull together to make this happen. That's why she went into care in the first place. This child has already tried the separate school where she's in care of a foster parent who was her aunt who knew her. She has tried regular school. She's been in...
That was when she was 4.
Yes, Your Honor, that's true.
Okay.
But that's where we're asking to go back to in the alternative. So I would say that there's...
Or 5, yeah. I'm trying to get the timeline in my head. She was 5 years old. Was she even in, I mean...
She was in a substantially separate classroom in a school.
A normal child would not be in school at age 5, or would just be starting kindergarten. They'd only be going half days.
Right. That's accurate, but she was going to school on a daily basis, and she was coming back home on a daily basis to the squalor that we talked about early on in the brief. What's different? What would be different if custody were to go to the father? He's alone. He has no other supports in the home, according to his testimony. This is a child with multiple exceptional needs. This is not just your regular child who's got some difficulties with...
Why does she have to be watched at this point, at age 9, which she was at the time of trial? Why does she have to be watched overnight? She can't feed herself.
Cannot feed herself.
But she can dress herself, she can go to the bathroom by herself, she's physically 100%.
And she can walk out the door and walk right into a street. Unless there's somebody there who can ensure her safety, Your Honor, she is not safe outside of a program that's watching her. Further, I'd like to say that the court has essentially laid out a roadmap for this father. These are the things that really need to be taken care of. This is how you get your child back. He has had several years' worth of opportunities to file for review and redetermination, yet we're here today, obviously because either he has not or he has been unsuccessful with that.
May I ask you one more question? And I may be mixing cases. So is there anything in the record that would indicate that this child had any tendency to be self-injurious?
She was initially. That's reduced significantly at this time, Your Honor. She was.
Is that at all a factor in the 24-hour keep an eye on her at night?
And the intensive applied behavioral analysis, which is the key component of the program where she's at.
Thank you, counsel. Thank you, all of you.
Honor.
You did a very nice job for your clients, and you helped us. Thanks to our court officers, our clerks, staff, and with that, we are done with today's sitting.